Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
I don't think I joined with audio. Sorry about that. We are the veteran of exactly one oral argument that happened at 10 o'clock this morning via Zoom. So I would imagine that Mr. Keltner and Mr. French are much more familiar with doing proceedings with Zoom than we are. So we would appreciate your patience in that regard. First argument went off without a hitch, thanks to the hard work of Ms. Williamson getting all the technology lined out. I believe she did a test with you on Tuesday. So with that being said, we're ready to proceed. The court at this time will call cause number 11-19-318 CV, Arrington Oil and Gas versus, is it Wilshusen? Mr. French?
Yes, Your Honor.
All right, good deal. All right. With that being said, we'll call Mr. Keltner if you're ready to proceed.
I am, Your Honor, and may it please the court. This court is certainly no stranger to TCPA cases, and there is no doubt that TCPA cases have certainly clogged the dockets of Texas. But make no mistake in this case, the Arrington defendants' use of the TCPA is exactly as the legislature intended, to get rid of tort claims that deal with the right of association and never should have been brought in the first place. After all, you look at the petition, Mr. Wilshusen's main claim is that he did not get what he was promised, a contractual claim. But to increase his damages, he went ahead and added 3 torts: conversion, conspiracy, and fraud. And those are what we contest. We do not contest in the TCPA motion the contractual claims and quasi-contractual claims. And again, make no mistake, we don't agree with them. We deny the allegations completely, and the discovery so far has been consistent with that, by the way. And I'll touch on that in a minute. We only go after the tort claims I just talked about. And the challenged tort claims all arise or relate to the exercise of the right of association by the Arrington defendants on a matter of public concern. And that was the Midland project, which was to drill horizontal wells. As I understand, there are over 7,000 leases under the city of Midland and certainly in the county of Midland. And let me also say, Mr. Wilshusen, in his affidavits and even in the petition, admits the public concern. He says that there were 7,000 leases covering 4,400 acres underneath the city of Midland. He was the face of the project with government officials and with the citizens of Midland, and met with the city of Midland, the county of Midland, and the Midland Independent School District. So whether required or not for public interest, we certainly meet that. Now, let me again say that what we allege today does not destroy his contractual claim. And again, we disagree with those. We believe he left his post in the middle of this project and left it undone. We deny the allegations regarding the communications, but that makes no difference to this court's ruling, and I'll explain why. First, I have to demonstrate to you why we fall under the right of association, and I'll call you to the definition of the exercise the right of association, which means, and I quote now, a communication between individuals who join together collectively to express, promote, and pursue or defend common interests. Now, Mr. Wilshusen in his appellee's brief spends 14 pages saying we don't even have a communication here. But if you look at his original petition, his TCPA affidavit, and the appellee's brief, I can demonstrate to you that his claims do involve communications. He especially ignores his original petition. But as the Texas Supreme Court told us in Hirsch versus Tatum, which by the way was adopted 3 months ago by this court in the Norvich versus Musa case, Hirsch told us that the basis of the legal action is what is important. A defendant can even deny the communication, as we do here. And still, if it is the basis of the cause of action, that is enough to establish a communication. So let's look at the various things in the petition, the affidavit, and his appellee's brief that demonstrated communication. I call the court's attention first to paragraph 79 of his petition. And what he says is, Arrington Oil and Gas, Midland Petro, Permian Deep Rock, in combination with Platinum, 3 Platinum, agreed to accomplish what essentially he alleges is a fraud. In paragraphs 80-84, he says they conspired together to convert into fraud. In other words, he is alleging concerted action. Now, these allegations certainly implicate a communication, but the appellee's brief in his affidavit makes that clear. First off, he says at page 59 of his appellee's brief, Arrington expressly instructed, this is a quote, expressly instructed 3 Platinum to refrain from making any and all payments. Now that covers all conversations. In his affidavit, he says David Arrington advised Amy Dodson to withhold any payments distributed to me. Again, another communication. And then back in his brief, he says that and this is in his attempt to prove the prima facie case, he goes so far as to say that email communications between the defendants established that some people got the same overriding royalty interest he claimed that he didn't get. And he says, and I quote here, that allegation, which is a communication, is more than enough to establish unlawful control and all 3 of his causes of action. Now, these are exactly the kind of communications that courts have held implicate the right of association. If you'll look at page 10 or 12 of our reply brief, we lay that out in great detail. And of course, Hirsch would justify that as well. Justice Stretcher's opinion in Caliber Oil and Gas does not really deal with what we're dealing with here. There he found that the communications were between parties on opposite sides. That is not what we have. So let's look at the final thing we have to prove, and is this a matter of public concern? Now, Chief Justice Bailey, I will tell you this. I know of your opinion in Blue Gold Energy and, of course, Norwich versus Musa by Justice Stretcher, saying we have to prove public concern. Regardless of whether that is actually required, and as you acknowledge, there is a difference in the Court of Appeals on that issue. But regardless, we've established it here. And Justice Stretcher's opinion in ETC Texas Pipeline demonstrates that. In that case, there were oil and gas leases involved and transportations of oil and gas dealing with the issues of oil and gas leases underneath the city of Big Spring. And the court, and Justice Stretcher said that certainly implicated a matter of public concern, and that is exactly what we have here. He also noted one other thing that is important that the Supreme Court noted, and that's in ExxonMobil versus Coleman, a 2017 decision. The Supreme Court held that the connection of public concern, now that was a free speech case, but as a matter of public concern, has to only be tangentially related to a matter of public concern. So the communication has to be only tangentially related. And we have that here as ETC says. Let me tell you exactly where we have that, and you can look in the record to find it. It is in the petition, paragraph 13, and I am quoting, Mr. Wilshusen says, the Midland project was a unique and expensive undertaking due to the fact that Midland Petro was planning to drill horizontal oil and gas wells under the neighborhoods and businesses located in the heart of Midland city limits. In paragraph 14, Wilshusen acted as the face of Midland Petro, attending countless meetings with the citizens of Midland and local government officials to discuss and propose drilling horizontal wells underneath the city. In addition, he says that he was the face and the representative with governmental entities. In his affidavit, he says he met with the citizens of Midland and he was the liaison between the defendants, the city, the county of Midland, and the Midland Independent School District. That's more than enough. And by the way, those are not my words. Those are his words in his affidavit and petition, and that's more than enough to establish the matter of public concern. Now, I'm not going to discuss it in detail now unless the court wants to. We disagree with the idea that the public concern is necessarily implicated or is required for the right of association. But we acknowledge this court is held to the contrary, along with several other courts. But as you know, other courts have held the other way, but that's not important to the resolution of the case today. The next question then is, if we do fall under the right of association, has Mr. Wilshusen proven all the elements of his cause of action? The law on this issue is abundantly clear, and the In re Lipsky decision, which was adopted, Chief Justice Bailey, by you in the Kinder Morgan case, makes
Hey,
clear.
counsel, before we go on, you kind of dismissed the Caliber opinion, and then let's just talk a little bit about Blue Gold. What's the public endeavor here? It looks to me like it sounds like it's a dispute between an employee and over an overriding royalty. What's the public interest here?
Good point, Your Honor. And again, it goes, I think, directly to a point raised by the other side, especially in the briefing file night before last. Let me address it. Your opinion in ETC dealt with the same thing. The actual dispute between the parties didn't deal with a matter of public interest, but the project it related to did. The same is true here. There's really no space between your opinion in ETC and the allegations in this case. He says what he wasn't paid for was a matter of public interest, and that is in his petition and affidavit. And I think he wrote directly into your opinion in ETC. My point on Caliber, Your Honor, was just saying that the facts in this case were that the communications were between the defendants. As you pointed out in Caliber, the communications there were between people on opposite sides that did not have a common interest or a shared interest among themselves.
Well, I know you disagree, but we have decided that the right of association requires a public interest. And if you look at our opinion in Norwich, we said it doesn't apply to a private pecuniary interest between a husband and a wife. And now I'm trying to see how you're distinguishing a private pecuniary interest between a company and an individual.
Well,
help me out with that.
Yes, sir. Again, astute observation. My point to you is this. Norwich certainly did not deal with anything that could conceivably relate to any right of a public interest, either the dispute between the parties or the whole transaction involved in the divorce proceeding there. ETC, on the other hand, the dispute did not deal necessarily with any degree of public interest in who would carry the oil, and a breach of a contract on giving oil and gas interests. Instead, the entire process or the entire transaction there did deal with a matter of public interest, which Your Honor held. Now, I'll acknowledge that that was a case involving free speech and not the right of association. But nonetheless, I think our position is that the same rules ought to apply and do apply. And the Supreme Court has been very clear that the speech in association cases look at the same kinds of things in doing that.
And I hear you, counsel. I hear you, and I understand your argument, but I go back to Norwich a little bit. This overriding royalty interest, how does it relate to the Midland project? How help me out with that?
Two ways, Your Honor. First off, he says, and I'm relying on his allegations, so you don't have to trust me on this. He says that those were due to him because of his work in the Midland project, which was a matter of public concern, and that his representation of the defendants before the Midland City Council, and I know you know something of that personally, and additionally with the County of Midland and the Midland Independent School District meeting with citizen groups, getting permits and regulations all relate to the public interest, and that is our position. It was enough in ETC, and it ought to be enough here. And Your Honor, I see nothing in Norwich that disagrees with your opinion in ETC. And I don't think I can't tell what Your Honor intended, but I can only read what you wrote. And I don't think that you mean to say that there are different issues there. All right, very briefly, let me go to the issues regarding prima facie proof. And let me say this, In re Lipsky gives us the map and what it says, and that's the Supreme Court decision. And what In re Lipsky says is that mere notice pleadings are not enough. And allegations and affidavits and other things are not enough either. You've got to say what is the who, where, when issues. And that is important. And in fact, in Backus versus Misko, the Dallas Court of Appeals by Justice Bridges back in 2015 defined those terms right at the time that Lipsky came out. In fact, the petition in Misko was denied about the time that the Lipsky opinion was published. And it says clear in the statute, because it has to be clear and specific. Clear means unambiguous. Specific means explicit. So that's what we have. Now, let me acknowledge one thing. In our original briefing, we took the position that circumstantial evidence and inferences are not permissible. That is clearly wrong. And our reply brief, I hope, corrects that issue. We acknowledge that is not the case. And In re Lipsky says directly to the contrary. But let's look at the Wilshusen's proof, and you'll see where I'm going with this. First off, his petition is a notice petition pleading. I don't think it helps in very much in that regard. Second, his affidavit is basically the same. But look at this, just on damages, we can destroy his cause of action. Let me explain why. In his affidavit, he concludes by saying the important thing. I have suffered damages in the form of the loss of my royalty interest in the Midland project and funds attributable to such interest. That is a contract measure of damages. It is not available in any tort. It is barred by the economic loss rule, period and paragraph. The economic loss rule is not an affirmative defense. And it does not deal, Justice Bailey, as you pointed out in Stallion Oilfield Services, it doesn't deal with the fact of damages versus the amount of damages. To the contrary, what it says is they can be no damages for that. So it deals actually with the fact. In Shop-Off Advisors, which we quote to you in the briefing in some detail, the San Antonio court dealt with exactly this situation and applied the economic loss rule to the same kind of torts, conspiracy, concerted action torts, finding that they were actually invoked the right of association, and also said the economic loss rule prevents recovery, therefore there are no damages, destroying the prima facie case. And it's important what Shop-Off said, because he went so far as to say this is not an affirmative defense. It's a legal consideration of what is damages, what are damages, and what damages are not. And it specifically said, and it is applicable on the question of whether Atrium, the plaintiff there, had met its prima facie case on the element of damages, and it found that it did not. Now, there are other elements too that relate to various matters, and in the few moments I have left, I'll cover them in more detail as they are discussed by the other side. but let me deal with a couple. In this case, there's no allegation that a specific overriding royalty interest was promised. And in fact, the petition, the affidavit, and the appellee's brief are silent on that. The plaintiff, Mr. Wilshusen, tries to say others were promised some and I ought to get what they get. So the really issue is, can that be conversion? Is there a specific fund to look to? Is there a specific chattel to look to? There is not. And as the Supreme Court has pointed out in the cases that we have given to you, that is a problem. And in fact, Justice McCall's opinion in Pascal versus Great Western pointed out that problem. Now, in that case, I'll admit that he found that it did relate to a specific chattel. But if you can't tell what the overriding royalty interest is, it's never recorded, it's never transferred, there's no way that you can be a conversion of anything but cash money, which is absolutely prohibited. Additionally, in the conspiracy claims, there are a number of problems with those, but the most is that these people can't conspire with each other because they're part of the same business organization. The Supreme Court decided that in Bradford versus Vento. Finally, in fraud, there's no allegation, there's no real suggestion that this promise was false when made. In fact, Mr. Wilshusen even says that it was a true promise when made because a 3 Platinum was formed to hold those alleged funds for him. We deny that, by the way, but nonetheless, that's his allegation. I see my time's expired.
Thank you very much, Mr. Keltner. Mr. French, are you ready to proceed?
Yes, Your Honor.
You
May
may.
it please the court. May it please the court. Good morning, Justices. My name is Matthew French. I'm out of the law firm of French Benton PLLC in Midland, Texas, and my law firm represents the appellee M. Scott Wilshusen. We appreciate the court taking the time to accommodate us and allow us to have oral arguments via Zoom. This is also my first argument, so I am right in the same boat with you. Today, what we're going to argue is that the court should affirm the holding in this case that the appellant's TCPA motion to dismiss was denied. This court has already ruled that it was denied by operation of law due to the fact that there was not an order issued in relation to that motion. I believe that point is moot because this court has already ruled on it. There's 2 additional reasons that we believe the court should affirm that ruling. The first is the appellants have failed to show how the TCPA applies to their right of association based on 2 recent opinions of this court, as well as several other appellate courts here in Texas. The second reason is because Mr. Wilshusen has made a prima facie showing of each one of the elements of his underlying causes of action of fraud, conversion, and conspiracy. I'd like to first address the issue of the applicability of the TCPA. When we briefed this issue late last year, we will admittedly say that in Stallion, this court had held that it had not yet made a determination whether or not there was a public component required as it related to the right of association when applying the TCPA's protections. Since we have briefed that, not only this court, but several other courts have taken that stance and made that decision. I believe this court made it in the Blue Gold decision. They affirmed it in the Norwich decision. We've seen where the Court of San Antonio Court of Appeals has also taken that stance in the Navarro drilling case. The Cowcaw, Fort Worth has taken that stance. Both of the Houston courts have taken that stance by reversing previous opinions. And so I think we've seen where the tide has turned towards the requirement of a public or citizen component when a movement is asserting a TCPA motion as it relates to the right of association. And I don't think that's any coincidence that this line of decisions has come out since the legislature has amended the TCPA. Admittedly, we have to apply the pre-amendment TCPA, but if we look at the Navarro drilling opinion in San Antonio, what the justices in that court said is it's not authoritative, but it's highly, it's something to be highly considered what the intent of was when the amendment was made to the TCPA. meaning it's highly persuasive, I believe is what the court said. And what the court looked at was how the courts have translated the previous version of the TCPA, which we're discussing here today, and how that is in harmony with the changes that were made to the TCPA. Namely, in the new amended version, there is a governmental or community component required when you apply the right of association. And so I think that what we're seeing is the appellate courts feel more comfortable with exerting these canons of interpretation and saying that, yes, this was the intent of the legislature, because we have to assume the legislature amended it because it was not in line with their original intent. And I think the first place to start is the blue gold opinion, which was authored by Justice Bailey. And in that opinion, this court expressly stated that the common interest component of the right of association under the TCPA means something more than an allegedly tortious communication between the individuals in the pursuit of a private business endeavor. The court went on to further say, rather, there must be a citizen or public component to the common interest in order to constitute the right of association as defined in the TCPA. And I think that's consistent with what several of the other courts have held. And I think it's this court's stance. I think to take that a step further.
But counsel,
Yes.
Let's talk about that public component for a minute. You're from Midland. You know, Midland is an oil and gas community. What would be bigger? What would be a more public component than this huge project that Arrington Oil was undertaking?
Well, Your Honor, I think from the perspective, I think on its face, what we have here, and I believe what's alleged in the TCPA motion to dismiss, is Mr. Arrington is a private businessman, and he has 3 entities that are private businesses that are engaging in an oil and gas project. If we look to the face of the pleadings, what is alleged in the motion to dismiss is that the school district and the city receive royalty payments in their capacities as landowners. If we look at Mr. Wilshusen's affidavit and pleadings, yes, we have the fact that Mr. Wilshusen did have to meet with the public. He did serve as the face of the project. He also communicated with Landman, who secured 7,000 leases. I'll first point out that those are all communications that were made by Mr. Wilshusen and not by Mr. Arrington or any of the other appellants. And I'll second point out that in the state of Texas, there are many public benefits to drilling oil and gas that don't necessarily implicate a public interest. For example, if you get a lease on a university lands lease, you're dealing with the state of Texas, but which affects the University of A&M and the University of Texas. But I don't believe that falls under the purview of the TCPA. There's not necessarily, these rigs are outside of the city and we're drilling vertically underneath the homes here in Midland. As far as the aspects of what we're alleging, that does not affect those people. And to go to the point of whether or not this is a public interest or not, if you do read our pleadings, one of Mr. Wilshusen's jobs was to go out and obtain leases and purchase minerals on behalf of the appellants. And the purpose of that was to raise the NRI of the drilling project, meaning the amount of money that Mr. Arrington and his companies would receive. The question came up as to where would this overriding royalty interest that Mr. Wilshusen says he's entitled to come from. It comes from Mr. Arrington and those companies out of that NRI that was raised. Part of Mr. Wilshusen's job was to purchase royalty interest so that the Arrington companies would get more money. And I think that goes back to Norwich, and what we looked at Norwich was, what is the basis of the causes of action that we're asserting? I think the fact that we have elaborately pled the circumstances surrounding Mr. Wilshusen's claims does not speak to the fact that if you look at the causes of action we're asserting, there's really only 2 things at issue here. Well, 3. We're saying that a private businessman and 3 private business entities work together to, 1, convert property that belongs to Mr. Wilshusen, and to 2, defraud him through fraudulent representations. And I would say to this court, those 2 things don't have anything to do with people who sign leases in the Midland project are the fact that we're drilling underneath the city of Midland. What they have failed to do is show how those relate to a public component. In the Norwich case, there was a similar allegation made by Ms. Norwich. Her statement was that because the underlying business dispute that her and her husband allegedly stole and misappropriated funds from involved the construction and operation of a hotel, that made it covered under the TCPA's right of association simply because that hotel operated and benefited the public in a specific marketplace. What this court did, and its opinion was, it said, even if that does affect the public, we have to look to the basis of the allegations made against Ms. Norwich, which were that she misappropriated and hid funds. And the fact that she misappropriated and hid those funds had nothing to do with the fact that the underlying business venture from which she took those funds operated a public business. And I think that's a similar conclusion that can be made here. Mr. Arrington, as an oil and gas operator that does have some benefits to the public, the fact that he is taking funds from Mr. Wilshusen has nothing to do with the fact that the Midland project is something that affects the public generally in Midland. And I think the best way to look at that is if we take the allegations that Mr. Wilshusen has made as true, which are the appellants conspired together to take his property and to defraud him, who benefits from that? The only people who benefit from that are Mr. Wilshusen, are Mr. Arrington and his three companies. In no way does that affect the public. And so I think our point there is that while the Midland project may touch upon public matters, the actual right of association that's being asserted by the appellants and what we are asserting in our causes of action, they have nothing to do with that. They don't contain that public or community component. I think in some of these other cases that Mr. Keltner has cited, there were overriding considerations such as a pipeline affecting the general public. I think that in some of the other cases they cite, such as Elite Auto Body, we have situations where we're affecting the greater marketplace because we have illegal competition, which changes the prices and affects public. So I think that a lot of the cases that they have cited can certainly be distinguished from this, because at the end of the day, the only people who benefit from the allegations that Mr. Wilshusen has made are private business owners and private businesses, which I think goes exactly to the heart of the ruling in Blue Gold and the ruling in Norwich. And I think we can, if we look at those specific communications, we can differentiate where the basis of the tort and what we're alleging is different than the overriding underlying business project, which is, I think this case is exactly analogous to Norwich, in that, yes, the business venture had something to do with the public, but the dispute was between the private business owners. And at the end of the day, this dispute is between Mr. Arrington and his entities and Mr. Wilshusen as it relates to his employment. And I would like to touch upon the communications that they're alleging that were made and point out some things. The first thing is they have alleged that Mr. Wilshusen stated in his affidavit that he communicated with the city and served as the face of the Midland project. That's a communication, but it's a communication that Mr. Wilshusen made. It's not a communication that Mr. Arrington made. It's not a communication that any of the entities that are defendants in this lawsuit have made. They allege that representations were made to Mr. Wilshusen by Mr. Arrington and by one of Mr. Arrington's employees. Those communications also have nothing to do with the public and affect the public in no way whatsoever. In fact, they've argued that even without Mr. Wilshusen, the Midland project has continued on and become a success. And based on the discovery in this case, there are clearly royalty payments being paid out. And so really the dispute between Mr. Arrington and his companies, Mr. Wilshusen, have no broader effect on the public or the Midland project. In general, they're nothing more than a business dispute. And so I think that they have failed to meet that burden to show that there is a public or community component, because at its basis, this is a business dispute to that effect. And I think that's consistent with what this court ruled in Norwich and in Blue Gold, and what several other courts have. And I think it also harmonizes with the changes that have been made to the TCPA, which we can look at as persuasive to show that that was not intended to be how this statute was used. It leads to an absurd result if we allow tortfeasors and their private actions to be protected simply because they joined together. And then on the second hand, to the argument that Mr. Keltner just made regarding the inability to conspire, I believe the case law that they submitted a couple of days ago to the court, the basis was on principal agent liability, suggesting that Mr. Arrington and his entities are essentially one and the same because they're all owned and controlled by him. Well, if we're to take that on its face, then under the TCPA, we need more than one individual to conspire, or not to conspire, in order to enact the protections of the TCPA, because there would be no other person for Mr. Arrington to associate with. So their argument fails on its face as far as applicability goes there, if they're going to make this argument that Mr. Arrington and his entities are one and the same. So I think under that theory, the TCPA is not applicable because it's one person. I'll point out to the court that in their brief, they do provide case law that says that an LLC is considered a person for purposes of the TCPA. So I think as far as meeting our burden for the conspiracy, we have shown that even if these entities are controlled by Mr. Arrington, they have all acted in concert. As it relates to the appellee's efforts to put forth a prima facie case as to each one of the elements, I'd like to go ahead and address the issues that were addressed by Mr. Keltner on that. I would put forth to this court, and I'll rely primarily on the evidence that we've provided, that Mr. Wilshusen has met his burden of proving a prima facie case of each of the elements of his conversion, fraud, and conspiracy claims. As it relates to conversion, the case that was provided by the appellants a couple days ago actually speaks to the fact that proceeds from a life insurance policy, which are considered future proceeds based on a future event, were subject to conversion. That case does also hold that money cannot be converted unless it's a specific chattel, but this court has previously held in, let me find it. It's in our brief, and I cannot find it in my notes, but this court's previously held, and it's referenced in our brief, that proceeds from the production of oil and gas can be converted. And in that case, it was a situation where proceeds were misappropriated by the operator and provided to the wrong party, and the party who the royalty proceeds were attributable sued for conversion, and this court allowed them to continue forward. And I think that's important to point out, because under Texas law, a royalty interest is a right to a future proceed, the right to future production of oil and gas. That's very analogous to the case that was provided to us by opposing counsel, which said the right to a life insurance policy was the asset that could be converted, which is the right to future proceeds. So I think that Mr. Wilshusen has established that an oil and gas royalty can be converted. As far as identifying the quantum of what is being converted, we do that in our original petition, and in the affidavit, Mr. Wilshusen clearly states that Mr. Arrington promised not only himself, but his executive counterparts, Mr. Ball and Mr. Busey, between a 0.05% and 1% overriding royalty interest in the Midland project. And I think we can quantify that through the circumstantial evidence we've submitted, which in the production by the defendants, we received run checks, or run statements, which allocated overriding royalty interests to Mr. Busey and Mr. Ball. And I think that's important because the courts have said we can use corroborative and circumstantial evidence to prove that we've made a prima facie case. And so what we have shown is the testimony of Mr. Wilshusen is he and his counterparts were supposed to receive those overriding royalties or payments equivalent to that. And we're showing that that in fact is happening with his counterparts, but it is not happening with him. That's also corroborated by the fact that Mr. Arrington told his accountant to withhold the payments that were attributable to Mr. Wilshusen. So I think that proves that we have met our burden of conversion, and I think the law allows you to convert a royalty interest. And at the end of the day, a royalty interest is a specific identifiable quantum of a production of the proceeds of oil and gas, which an operator should hold in trust for whoever owns the royalty interest. So I think we've met that burden.
Okay, counsel, we've got about a minute and a half left. Let's circle back. Your position is there is no public component, period, zero.
Yes, Justice Stretcher, that is our position. As it relates to the dispute between Mr. Arrington and these entities, as this court's directed, we have to look to the allegations made by Mr. Wilshusen in his complaint, and that are the basis of the claims that are being challenged. And those allegations, once again, are simply that a private businessman and his 3 private business entities have converted property and defrauded Mr. Wilshusen, and they've combined together to do that in a conspiracy. We would refer back to Norwich and state that even though the basis of the Norwich lawsuit was the hotel, the allegations made against the parties that were involved in the hotel's construction had nothing to do with the public component of the hotel, and that the fact that the business venture had to do with the hotel had nothing to do with the basis of the lawsuit, which were the torts that were committed against the private business owners. And as I said before, the only people who are going to benefit in this situation are Mr. Arrington and his 3 companies, because they are the ones who are converting the funds. In no way do those actions or the communications of Mr. Arrington and his co-conspirators affect or have any public component. And so I believe on the face of the matter, the appellants have failed to meet their burden that the TCPA applies under the right of association due to the fact they have not alleged a public component and shown that. I would also implore the court to consider the fact that Mr. Wilshusen has in fact pled a prima facie case for each of the elements of his causes of action. And for that reason, we would ask the court to affirm the denial of the TCPA motion to dismiss.
Thank you, Mr. French.
Thank you.
Mr. Keltner, we'll go to you for a brief rebuttal.
Oh, there we go. I was finally able to unmute. I'm sorry. I'm going to address 2 things in the rebuttal. One, Justice Stretcher, your comments about public concern, and I understand where you're coming from. But first, I want to talk a little bit about what I ended on and what Mr. French ended on, and that is the issue of the prima facie case. Let's take fraud, for example. Is there justifiable reliance? Can't be. And let me explain why. The December 2016 independent contractor agreement disclaims reliance on anything but that's in the agreement and says there can be no oral modifications. Mr. Wilshusen brags on the fact that he is an accomplished lawyer, saying that he has negotiated over 1,000 contracts regarding with oil and gas. How can you rely then on an oral, non-recorded transfer of a mineral interest, either severed or not? You can't. And how can you overcome the reliance issue on the 2016 agreement? That is not possible. That is probably why the trial court in its letter indicated that he would grant as to the fraud cause of action. I'm not claiming, by the way, that that became a final order. It clearly didn't, and I think the court was right in your earlier decision on that one. There are other matters as too. Again, no one has, Mr. French did not address the economic loss rule, which the Sopoff court said was decided the issue. That applies to every damage amount that he alleges, both as conversion and fraud. And of course, conspiracy doesn't have its own damage amount. It relies on those 2 torts. So those types of things, I think, are deadly to his prima facie case. Let me turn to the right of public concern, and I'll address Norwich first. Norwich, the hotel being a matter of public concern, was always a stretch, and the opinion sort of indicates that. I understand the private communication being different than the hotel, but they were different transactions. In ETC, and I pulled up both ETC and additionally Coleman, on which it relies, the court looked at a similar situation. Remember, in ETC, we were talking about The complaint was, I didn't get the oil and gas interest to which I was promised in a project that had a public concern. And here's what the court says. It says private communications made in connection with a matter of public concern fall within TCPA's definition of the exercise of the right of free speech. I'll admit this is an association case, but the principles are the same. And the court goes on to say the TCPA applies so long as the movement statements are in connection with issues related to the matters of public concern, relying on Coleman versus ExxonMobil. And in Coleman, the Supreme Court reversed on that very issue where they didn't hold that it was a matter of public concern. And the court said, instead, the Court of Appeals improperly narrowed the scope of the TCPA by ignoring the Act's plain language and inserting the requirement that communications involve more than a tangential relationship to matters of public concern. Those are important rulings, and they're important to this case because there's no doubt this was a matter of public concern. And by the way, when Mr. French says those communications were by Wilshusen and don't count, he misses the boat. The truth of the matter is those were comments first by Wilshusen on behalf of Arrington before the dispute arose. And they were matters of public concern. And that's what he says he didn't get paid for. It is the exact same, in fact, completely analogous to the ETC opinion. And a different result would not make a difference here. Based on those provisions, we believe just on the torts, not on the other matters, that we have proved the application of the TCPA and that there is no prima facie proof of the three torts that would survive that challenge. And as a result, we ask you to reverse either on the fraud alone, which I think is relatively clear, or on all three torts. Thanks. Thank you very much.
Thank you very much, Mr. Keltner. Judge Stretcher, did you have something you wanted to say?
No, I was just going to say good job, counsels. Very good arguments, good briefs, good job.
Thank you, Your Honor.
Thank you, Your Honor.
With that, the case will be submitted and Ms. Williamson will close us out.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.